Perfect. Last few have just drifted in. So again, good morning, everyone. Thank you for attending again. As always, great to see so many familiar faces with us this morning. Today kicks off start of our 2022 seminar program. Hopefully will be a bit more of a different year than the last two in terms of our seminars. Obviously today's event similar on a webinar function, but we are actually hoping from April onward. Apologies there, I think I was muted by someone else, so hopefully everyone can now hear me. Put thumbs up if you can, would be great. If everyone else can mute themselves, however, that would be perfect. So again, apologies for that. As I was saying, start of the 2022 seminar program, we are now hoping to do some events in person as well. We will continue to record them all, make them available on our YouTube channel and our other social media platforms. So we will let you all know about those details. But again, thank you for attending today to kick off our 2022 program. In terms of today, we are talking social media and banter in the workplace. Something I haven't actually presented on in a number of years. This used to be one of our staple events that we've presented a lot on, obviously due to COVID and the focus on furlough and the COVID restrictions. Not something we've had a great demand for recently. However, as people are now returning to the office, obviously communicating via social media, these issues are coming back, something that we're dealing with in practice now on a regular basis. So something that is going to become more prevalent as people now come back into the office in bigger numbers and are working closer together after for some organisations. I appreciate not everyone here, where there has been not attendance in the office for a number of years. Again, something we're all seeing with Chadwick Lawrence, when people have been used to working away for 2 years on their own in absolute silence, coming back into the office can present some challenges. So really topical thing to discuss today. I'm now just going to share my screen with you all, so you can obviously have a look at the slides. So, as I said, social media banter in the workplace. So what are we talking about today? I'm going to try and split the event up, dealing with a mixture of the law, obviously, which is derived from the Equality Act. We'll talk through some examples, both in the public eye and practical examples I've been dealing with social media issues and workplace banter. We're then going to have a look at the tribunal, cases that are coming out of the tribunal, again on a variety of cases, but focusing on obviously social media and workplace banter. Finally, we'll have a bit of a chat about, what you can actually do about this. How do you protect yourself as an organisation? Hopefully, how do you prevent these types of claims occurring? And what can you do with policies, processes to make that, both to give you the added protection, but also to hopefully prevent these claims. Where I'm going to start today is with some recent matters that have been in the public eye. As one of my many roles at Chadwick Lawrence, I'm also a member of our sports team, and as well as advising a number of regional sport clubs. What that involves is often presenting to the team of players about what we call a code of conduct issue. So I did this at a club last week, and some of the things that I was talking to them, I thought would be really prevalent to share with you guys today, because although sports clubs can be obviously have a higher profile, lots of the learnings that you can derive from the sports industry can be absolutely applied whatever the size of your business. So again, apologies for anyone who isn't a particularly au fait or big sports fan, but I'm just going to focus on three matters that have been in the news over the last probably year and a half, and part of what I spoke to the players at the rugby club last week. So again, if I was doing this in person, I'd ask for hands up and I would ask for suggestions of who these three people are. The one in the middle you might be most familiar with, because that is the most high profile recent case. So that chap is called Kurt Zuma, and he is the one, if you have all seen it, that has been recently in the news because he has kicked and hit his cat, which was then posted on by his brother, helpfully, I think on Snapchat, which was then publicized to the world. So there's three people in this picture, all sportsmen, 2 cricketers and a footballer. So the chap on the left is an England cricketer called Ollie Robinson. The chap on the far right is Joe Clark, again a county level cricketer who plays for Nottinghamshire. What these three people represent, and what I was talking to the rugby guys about, is when I'm dealing with social media cases for both sports clubs and, as I say, for any other organisation, especially for the larger ones, there I would say 3 groups of main social media issues that you get. And these 3 chaps represent each one of those. So issues with historic tweets, issues with videos, images being posted privately or others and then shared. And then the third one, obviously not absolutely social media, but WhatsApp groups. So they're the 3 big issues that we're seeing. And one that I think in each organisation you need to be aware of, and to make sure that we have a process or way of dealing with this. So to go through them briefly in a bit more detail about what the issues were. So chap on the far left, Ollie Robinson, he was just starting his career and playing his first test for England about 2 years ago, when obviously then becoming more in the public eye, playing the first game, the first test for England. Someone has then gone and traipsed through what is probably 18 years, maybe 10 years worth of tweets, and then uncovered some historic tweets that Ollie Robinson's made when he was 18. I won't read the tweets, they're rather unpleasant, but they are very sexist and racist in tone. Made as an 18-year-old young lad, starting out his career. They have then been uncovered whilst he's then become in the public eye. As a result of that, his what would have been a first appearance as England has then been tarnished by news reports, being in the media, having to answer these tweets that he's made. He has obviously claimed that this was done, when he was 18. He doesn't stand for these issues and views anymore, and he was, quite regretful about them. Irrespective of that, he's then been suspended from playing. He's been fined, and he's had a period of suspension to deal with. He's since turned back around his career and is playing for England again. But what I was saying to the players last week is the importance of Twitter in particular, or any social media, when you are in a public role. And as I say, this does apply absolutely for organisations, because you will have to stand for anything that you have said, privately or otherwise, for the last however many years. People mature, people change, people say things that they probably regret. What I talk to the rugby players about is doing sweeps and scrubs of their social media. If you are coming into a high profile role, do you need to have anything that is historic in nature? And I think that can again apply to your guys' businesses. Anyone new coming in, you as part of an induction process, you're addressing that yes, social media is a private thing, but if you are wanting to publicly identify yourself in this company and support them, you need to be careful that someone doesn't go back and look at all your historic tweets. So, a review of that as part of an induction, at least addressing that as a part of an induction, is something I would always recommend. The chap in the middle, Kurt Zuma, I won't spend much time on this. This is, clearly something that, most people in their right mind wouldn't do. It's been taken, as I say, by a family member, then posted. He is now going to have to live with that again for the rest of his career. There's talking about criminal prosecutions. There's talk about him being prosecuted in France, where he is from, and he will have to pay the consequences for what was images posted on social media. Again, I don't think there's a suggestion of this, but this is what you get often in the workplace, where there's groups going out. Often if there's alcohol involved, there are things that are posted probably in kind of rashly. But once it's gone, it's gone. You can't claw it back. Once it is out there in the public domain, it's out there for everyone to see. Again, I think the learnings for people at any level of business is that once you've done it, you can't get it back. And if the help of these stories, if anything, to share with members of staff is to show that and maybe make it form part of any social media training or education. These type of cases where once something is said, it's very hard to retract. Final chap, again, cricketer, plays for Nottinghamshire, called Joe Clark. He used to play for Worcestershire, another county. He, again, very detailed case that I won't go into, which came as actually part of a criminal case involving one of his teammates, a chap called Alex Hepburn. Alex Hepburn is actually now serving time in prison for rape. What came out of these cases was it was a classic example of a team WhatsApp group, where you had a group of players all associated to the club. Sorry, some people are just joining the meeting. All associated with the club, sharing messages, images that weren't to do with their job. Again, pretty unpleasant case involving a group of, as I say, male players at Worcestershire, basically using WhatsApp to grade, score, and count how many women they slept with. This was uncovered as part of, a criminal case. But then Joe Clark, again, a promising cricketer, has been suspended, disciplined, fined for that action. This is, again, an extreme example of something that we see all the time with businesses, which is groups of colleagues having WhatsApp groups, probably for very innocent purposes, But then, because of what we're going to kind of talk about, this idea of banter, things that are starting to be shared that are connected to work or can be offensive. The other issue about WhatsApp groups is you often have people who are in the groups but don't actively participate. So this is issues for two reasons. One, that these people obviously who are in the group but don't participate may still read the messages and be offended by them. And just because they don't leave the group or say they are offended, that doesn't mean that that isn't the case. And we'll come on to talk about harassment claims. The other more, again, serious issues with something that Joe Clark has gone through, although obviously there's a number of recent cases involving the Met Police of people losing their jobs and being disciplined and suspended and having financial sanctions, not because again they participate in the chat, but the fact that they are in that group where some, again, really unpleasant material is being posted. So they don't actively participate, but the fact that they are in the group has meant they are deemed to participate in that. So whenever we're talking about social media training, social media awareness for members of staff, I find these three types of cases to be the most prevalent and ones that you can use to educate. Again, know your staff. You don't have to use sports cases. There's others in the arts, as I say, in the police or other public profiles. But it's some really good learnings from things that people will be aware of. Just going through that in a bit more detail, focusing on social media before I kind of talk about a bit more of the law and workplace banter. So again, issues that these kind of cases have highlighted, and issues that you will have to deal with. That first one is that kind of thing that we've just talked about, the WhatsApp, the blurred line between personal and professional. I think that also goes from other platforms, and many members of staff, we do it at Chadwick Lawrence, are encouraged to go on social media, and they're encouraged to go on social media and promote and retweet and like and share posts made by the organization or high profile members within that organization. So we have to be aware as a company, if we are encouraging people to go on social media and do that and represent the organization, well, they will be doing that and then very publicly making a link between themselves and that organization. If they then do things that they shouldn't or post things that they may feel are suitable or they may feel is their right as a private individual to make, if it as an organization that's not something that we wish to stand for, we need to be aware of that. So that real conflict between personal and professional is something that's really difficult to overcome. Conduct, we've talked about. Issues, obviously, when we'll come on to claims, the inappropriate behavior, the images, the comments, that's the issue then you have to deal with. Lots of social media, we're talking about claims that ultimately end in unfair dismissal linked to conduct dismissals. This is generally gross or misconduct matters that we are dealing with. As part of that, what we look at often in these cases is your company's reputation. And where companies often get themselves into an issue is that they see comments that are quite rightly offensive or at the very least unwise, and immediately say, well, that is gross misconduct because you've damaged the reputation of the company. Reputation is something that is very important in these types of claims, but can't be assumed. The tribunals now are a lot more sophisticated than they used to be, and they will always look at, well, actually, has this caused any damage to reputation? So that means they will look at the individual's followers, how long the post was made for, how many views, how many engagements with that post. to see, well, actually, has this damaged reputation, or is it just something that that person has done that is unwise and you know, maybe a lower count of misconduct. What's the number? Fourth type of issue, obviously, we're seeing is leaks of confidential information. Again, it would take a seminar on its own to talk about, but again, big issue when people are obviously leaving organizations, especially if they are in a sales type position, is the confidential information they hold probably on their personal social media profiles, LinkedIn being the classic example of that. And therefore there is a question of, well, whose property is that, whose information is that, and you know, and is the social media being used as a vehicle to leak that confidential information about the company. So again, really important to address in your social media policies. You're at an induction, if you're dealing with a sales type force, or anyone who deals is client facing, really. You know, what are you doing with social media? Are you asking people to use their personal profiles? Are you setting them up company profiles? How do you store the data? How do you allow access to that? So something that needs to be addressed, because it's a real common issue on exit. Final issue, and again we'll touch on a bit more detail, is obviously claims. What we're trying to avoid here, and in all these cases, is claims. I'll talk about, in the purpose of today, really two main types of claims: unfair dismissal and discrimination claims, probably linked to harassment. Again, could spend all day on all of that, but they're the two main types of claims you see out of social media or workplace banter type issues. So just to kind of move on and really a bit of a whistle-stop tour of discrimination. As I said, defined by the Equality Act, was where all our discrimination legislation comes from in the country. We are actually doing, I know a number of you signed up already, a second event which will focus on other areas of discrimination. Today we're mainly going to talk about harassment, which is the most common issue when we're talking about workplace banter. But again, just as a bit of an overview, obviously in the Equality Act, four main types of discrimination: direct, indirect, harassment, victimization. When I'm dealing with this in practice, both for clients, either claimants or respondents, there is often language used that says, I have been harassed, or I have been victimized by a colleague. The word is often used in a more as a lay term rather than a technical one. And especially harassment or victimization, which is not what it means in the law, is bandied around. I have been harassed by this person. The misunderstanding, obviously, that again a lot of you guys will be aware of, is that there is no freestanding claim in harassment. What harassment is a type of discrimination linked to someone's protected characteristic. And again, that's what we're generally going to focus on today. If we were doing this again in person, we'd have a bit of a quiz and we'd go through all of the 9 protected characteristics. But to save you the test and the inevitable gift that follows, just to go through them there, and they are the 9 protected characteristics. So age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, sexual orientation. So as I say, that kind of misnomer really that's said in passing, I've been harassed. Well, it's on the grounds of. So you can have people who unfortunately receive treatment or unfavorable treatment, but it's not linked to a protected characteristic, and that which is the key. Again, they may have claims in constructive dismissal to say that their contract is being breached, but ultimately, if you are looking at harassment, you are looking at protected characteristics. Again, each protected characteristics, the claims in discrimination are different. When we're talking about workplace banter, again, it is mainly, and I stress mainly, the four on your right that you see most commonly in harassment, and probably sex being the most common we deal with. Absolutely, you can get age discrimination cases that we deal with a lot, but those four and probably age are your most common. But yeah, unfortunately, sexual harassment is the one that we get most of the time. To kind of drill down a bit more into harassment and really to define it under the Equality Act, because this is the key when we are defending these types of claim. We'll go into it in a bit more detail shortly, but obviously harassment, we are normally dealing with a case where it is one individual harassing another individual. We all today obviously are here representing organisations. Generally, we see in harassment claims, we'll talk about the principle of vicarious liability. So the organisation being responsible for the action of an individual. We'll talk about a defence to that in a case where we could have no knowledge or nothing, although there's nothing we can do to prevent that. But ultimately, when you are seeing these in practice, 99 times out of 100, they are brought against the organisation. Reason for that, obviously, is the organisation has bigger pockets. If it was something that we were pleading for a claimant, we would generally go against two parties, the perpetrator who's made the comments and the organisation. So another good training point for your staff is a bit of shock and awe, is to say, if you are found because of this workplace banter to have harassed an individual, that it's you who can be financially liable as well as the company. And that's a case that reflects that I'll talk about at the end. So it can be a very good training mechanism. My only bit of reading from a statute today is I will obviously just go through the definition of harassment defined by section 26 of the Equality Act. So what that confirms, and we'll go through the bullet points, but I'll just kind of go through the test. So employees are protected from being harassed on the grounds, as we've talked about, age, disability, gender reassignment, race, religion, belief, sex, sexual orientation, by any third party, including customers and suppliers. In the key definition is as follows: a person, A, harasses another, B, if A engages in unwanted conduct related to a relevant protected characteristic, and the conduct has the purpose or effect of violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for B. A also harasses B if A engages in unwanted conduct of a sexual nature, and the conduct has the purpose or effect of violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for B. In deciding whether conduct has the effect referred to above, the following must be taken into account: the perception of B, the other circumstances of the case, whether it is reasonable for the conduct to have that effect. So we've gone through those key bullet points on the screen. So we need unwanted conduct, the purpose or effect of violating dignity, creating an intimidating, hostile, degrading, humiliating, or offensive environment, relevant to protected characteristic. The perception of the employee is important, and then that key test of reasonableness, reasonable for the conduct to have that effect. With harassment, we don't need to show a comparator. So we don't have to compare how someone without that protected characteristic would be treated. So that, again, is different to a case of, for example, direct discrimination. So the key really is that perception and reasonableness. They're the key subjective summaries in harassment cases. But you'll see it's pretty wide definition there in terms of harassment. So this is why these cases of workplace banter are often caught up in claims and harassment. Again, won't go through an exhaustive list of treatment, but usual matters that we are seeing in terms of sex discrimination, questions about person's sex lives, displays of explicit material, whether that is the old-fashioned calendar on the wall, whether that is images on phones, on social media, sexual demands by, again, members of the opposite sex, indecent remarks, demeaning remarks, often about appearance. Again, they're the common ones we are seeing in practice. To give this a bit of flavour and a bit of substance, final bit on the law I was going to focus on is some of the cases from the tribunal, some older than others. There are hundreds and hundreds of these. So if you ever had a few hours, you can go on the list of judgments from the tribunal, and I would probably guess 1 in 5, 1 in 10 would be claims involving harassment or workplace banter. I'm going to focus on, as we have today, probably 3 areas and 3 types of claims. So there are the social media type breach, which results in unfair dismissal type claims. There's the harassment one that we've just talked about and potential vicarious liability. There's then the sometimes which claims that aren't harassment but still discrimination claims, looking at workplace culture, and again this idea of it was banter. Generally, and if we are ever as I say, pursuing claims for claimants, and a defence of banter is made, this is when we generally know we're onto a winner. But to go through a few of these in a bit more detail, a bit of a historic case now. 2015 case of British Waterways Board versus Smith. This was a case that again went all the way to the EAT. So there was an initial judgment, and then that decision was appealed. Basic facts of the case: Mr. Smith worked for British Waterways Board as a manual worker from April 2005 to June 2013. In June 2013, summarily dismissed for gross misconduct. He worked for a team who were responsible for the maintenance and upkeep of the canals and reservoirs. The disciplinary policy provided for dismissal for gross misconduct, where a serious breach of a policy can be used as an example. A social media policy existed, and that prohibited any action on the internet which might embarrass or discredit British Waterways, including defamation of third parties, for example, by posting comments on bulletin boards or chat room. Mr. Smith raised a number of grievances. When a mediation was arranged to deal with one of them, a manager supplied incriminating comments Mr. Smith had made on his Facebook page to HR. On arriving at the mediation for the grievance, he was then suspended pending an investigation. The suspension and the investigation looked at comments made in 2011, which related to drinking alcohol while he was on standby, a practice that wasn't allowed because obviously he was on standby. He made, in this case, a number of comments. There was 10 plus comments that he's made. I'm not going to kind of go through them all, but just to give you a flavour of them, again, top one on standby tonight, so only going to get half pissed, lol. I'm on vodka and apple juice for the first time. I've tried it, not too shabby. Why a gaffer in this place such? P word? Is there some kind of book teaching them to be total W word? Again, that was the flavour of them. Bit of damage to reputation of managers saying things, but also obviously the key issue of him drinking while on standby. He was, following a disciplinary hearing, summarily dismissed. He did lodge an internal appeal, which was unsuccessful, and he then made a claim. At the original employment tribunal hearing, it was held that Mr. Smith's dismissal was unfair. Whilst the judge confirmed that the process and the procedure followed by the company was fair, he adjudged that in his view, the decision to summarily dismiss fell outside of what we call the band of reasonable responses. I think a number of you have been on previous sessions I've done on disciplinaries, and we talk about that principle of the band of reasonable responses. The tribunal judge held that they had not taken account of mitigation in including the individuals in blemished records, and that the company had been aware of the comments for some time, so they were quite historic in nature. So again, that original tribunal decision shows that even when you are having comments that are, clearly offensive and clearly a breach of the policy, if we're not mitigating, if we're not taking into account length of service, unblemished records, that we can potentially face claims in unfair dismissal. The story with Smith then goes on, however, and this case then goes all the way to the EAT. The EAT, the Employment Appeals Tribunal, actually overturns this decision and deem that it is a fair dismissal. What the EAT criticises the tribunal for is it often is a matter for the employer to decide whether it was in this band of reasonable responses. So unless the decision was absolutely unreasonable, that in his view of in the appeals tribunal, that the matter would have been in that range. So again, it shows often the vagaries in litigation with these types of cases. A lot of this is going to come down to that issue of a band of reasonable responses. Personally, I feel that British Waterways Board were relatively fortunate to get that overturned on appeal. Yes, clearly the comments here were inappropriate. I think there are some learnings that that I would want you as organisations to follow from that. The point of how historic these comments were and that they were aware of them, I think, is an important one. We talked about damage to reputation. Are these type of comments really damaging the company's reputation? Probably not, in my view. Yes, there is some clear issues with the management, and the comments were made, and there's a clear issue him drinking on standby. But purely to focus on this as a damaged reputation claim, I think would be questionable. So these are the types of cases that we see a lot, which are borderline. One of the lessons in social media, if you are and again, I know a number of you are in HR, where you are often the first port of call in these cases, is to try and take a step back. When these cases blow up, we often get a call as a solicitor saying, this has happened, how dare they, we need to get rid of them as soon as possible. Often when you take a step back, you look at the case, you look at the damage done, it's not as bad as it first would seem. And the cases, as I say, that get themselves into trouble are those that react immediately. Again, here there was clearly a policy process followed, which is helpful. But the snap judgment to dismiss, that then you really are in trouble with these types of cases. Moving on, again, I won't go too much into explanations of what this claim would mean. It's a lot to do with sexual innuendo. I will let you do for anyone who doesn't know the terms, I'll let you do your own research. This is again a claim in harassment involving an individual, Miss Pruitt, and Green King Services Limited. Involves a pub manager who was being subjected with jokes and which involve sexual innuendos. Two employees, Mr. Gaunt and Mr. Bentley, were sat at a table and invited Miss Pruitt to join them at the table. Whilst Miss Pruitt sat down, Mr. Bentley asked Mr. Gaunt, "Do you know what a growler is?" Mr. Gaunt replied, "No." Mr. Bentley then spoke to the claimant and stated, "If you know, don't tell them." Later, Mr. Bentley told a joke about a bloke saying when he was asked for a growler, "And I didn't want a pork pie." Again, dealing with a case that really is this classic we were only joking was the defence. What the tribunal held in this case is whether it was meant as a joke or not, this was deemed to be offensive. So tension might have been to a joke, but it was still offensive. Claimant in this case brought a claim in sexual harassment. Interesting technical part of this claim is actually brought out of time. So claims generally again have to be in harassment have to be brought within 3 months of the act, unless we can show a chain of causation. What the tribunal did in this case, and I think something that is becoming more common than it used to be, is that the tribunal exercises a discretion to extend the time limit in this case. So despite the time being out of time, the claim was allowed, and Miss Pruitt was successful in the claim in harassment and awarded a pain and suffering award of £5,000. So not a huge claim, it's a one-off type comment. So again, without becoming too technical, for those who are aware of it, pain and suffering claims are banded. This is likely a low vento band type case. But again, classic example of things you will be seeing, which is comments made, passed off as jokes, but then obviously resulting in a harassment claim. Final one to claim to focus on before I look in quickly in terms of defences. Recent claim, Anna Lactus versus Barclays Bank. Quickly in terms of the facts, Miss Lactus, a junior banker, claims direct sex discrimination for the use of the word bird repeatedly in the workplace. So again, we're not talking about harassment claim here, but again, very similar things that we talked about. She claimed that her manager, Mr. Kinghorn, referred to female employees as birds. The claimant objected to the word, however, he continued to use it. To establish whether she had been directly discriminated against, the tribunal has to consider whether she has been treated less favourably and the treatment was because of her sex. The judge described it as plainly sexist, and any reasonable employer would consider this to be a disadvantage. The term was used to refer to women, and they was therefore held to be blatantly because of her sex. So again, classic case of what is known as workplace banter. So even if there was no malicious intent, we can still see things amounting to discrimination. So again, something that is absolutely vital in these types of cases are really good to highlight when we're talking about training, whether that's equality and diversity, whether that's social media. This workplace banter, it doesn't really, the intent is not the important thing. Finally, just to finish off the case, so really important cases for the groups here today representing respondents is what we call reasonable steps defence. What the reasonable defence does is allow employers to defend a harassment or discrimination claim if they can show that the company took all reasonable steps to prevent the employee from committing a discriminatory act. So again, this comes into when we were talking about who ultimately is being sued, whether that's being an individual or the organisation. So this is your ultimately defence to a vicarious liability issues. So two cases to quickly talk about. Leader versus Leeds City Council 2019. Mr. Leader described himself as Afro-Caribbean and was the subject to racist comments by another employee. Whilst these were not intended to be discriminatory, in the view of the tribunal, they did amount to workplace harassment. The tribunal, however, held that the respondent did everything they could to inhibit any racist behaviour within the workplace and were therefore not to blame. The employee who made the remarks were personally held liable in order to pay £2,769 to the claimant. So again, this is a case where the actions of in this case, Leeds City Council, were deemed to have been doing everything they could to stop this. This is through training, policies, practical things they were doing on the ground to try and attempt to stop these cases. You cannot stop as an organisation everything that is said by your employees. The key is, did you do that in everything that you could? And that's what we'll kind of touch on in a bit in terms of how we will achieve that. Contrast to that case is the final case that we'll talk about today, LA UK versus Gellin. This again, employee raised allegations of race discrimination by another employee. Employee was dismissed for poor performance and following the dismissal raised a grievance for racial harassment by another employee. The respondent investigated this and found that there had been racist comments made and requested that the employee sought further equality and diversity training. Some of the comments related to him driving a Mercedes quote, like all Indians, and comments that he should work in a corner shop and question why he's in the country. During the tribunal claim, it came to light that the employee reported these comments to his manager, but the action wasn't taken any further. The employer sought to rely on the reasonable steps defence, citing that there had been equal opportunities and anti-policy provided and training provided in 2015. Critically, the tribunal held that the employer cannot rely on a stale equality and diversity training in order to utilise the defence. It is not sufficient to provide one-off training and rely on these as reasonable steps. Training should be consistently monitored and updated to refresh employees' knowledge and awareness. I think if we take anything from today, it should be that case and that failure by the organisation. Many organisations that we act for will have equality and diversity policies, and they may have some form of training on induction. I would say it is rare for that training ever to be repeated or that training to be updated. And this question of it becoming stale is an absolute critical one. So when we're looking at our organisations, if we are not doing these things regularly, which probably means annually, and we're not doing them for all new starters, it will mean that reasonable steps defence is much harder to make. And that really can be the difference between a judgment in your favour or not. So really critical action. What that leads to, just in the last 10 minutes as a nice kind of summary, is what should you do? And that is exactly what that last case deal with. So I'm going to focus on this slide on inequality and diversity, and then mention social media again as a conclusion. Key point there, again, if you're not doing it, provide equality and diversity training. What does that involve? Again, it should be tailored and bespoke to your organisation. There are online tools, there are online training that are okay, but really this needs to be something that is addressed with your team. Again, if this is something you need help with or would like this to be run by, this is something that Chadwick Lawrence actually do and for a lot of our clients and can do, and we can come and deliver that equality and diversity training for you. Again, as well as the training, the policies are important. Policies on equality and diversity, harassment, social media, any kind of electronic media policy. The importance with the policies, again, which the next point talks about is the review. But more than that, it's important that the policies link, and that you don't just have a standalone policy that has no bearing on the other. So those 4 policies listed are classic examples of that. They need to link to each other. So social media policies need to link to your equality and diversity, which need to link to your anti-harassment policy. All those policies then need to link to your disciplinary policy and link to your grievance policy, so that when we're following that, we are making sure that those matters that fall between the two or three issues are consistently dealt with. Again, regularly review and update your policies. That's few reasons. One, the law changes, which it obviously does from time to time. Equally, the application of the law changes. We just talked about one of those recent cases. When we're talking about social media, again, that changes all the time. We're talking about new platforms. We're talking about how social media is used. It's something that as again, this is not a comment on age, but talking from personal experience, as you get older, it is harder to be aware of all the different types of social media. So again, update, be aware, talk to people on the ground, find out that, educate yourselves. Again, educate your employees of those legal risks. So when we're talking about equality and diversity training, by all means, use some of the material I have talked about today. Those cases that are in the public eye are really good to kind of make people aware. Use the case of Leeds City Council, where the company weren't held liable, but that individual was. Thousands of pounds awards, many employees can't afford that. So it's something that is important. Deal with complaints appropriately, kind of self-evident. There is, again, I won't talk about it too much, but as a firm, we were involved in a very high-profile case representing, obviously, Azim Rafiq versus Yorkshire County Cricket Club, which I'm sure a lot of you are aware of. Without going into detail, a case that the absolute headline is the complaints weren't dealt with appropriately or at all. Quality and diversity, the cases that we're seeing, these are issues that it's a top-down failing. The higher profile claims it's not individuals, rogue individuals going out their way. Often when you are seeing these issues, it is because of a cultural deficiency within the organisation. And again, so when we're doing our training, when we're doing our policies, this isn't a tick the box exercise to involve the new starters, the lower salaried employees. This should be something that is front and centre and probably led by the leaders in your organisation, because then that shows to the rest of the team that it is being dealt with properly and taken seriously. Finally, just to finish off, perfect timing, just turn of social media top tips. Again, we've addressed a lot of this today, but it's useful often as a reminder to your staff and a reminder for your organisation. Self-evident, we talked about it constantly. Develop a policy. Have a policy that isn't just in the back of a handbook or as part of the electronic communications policy. Have an absolute freestanding social media policy. Update it, make it relevant. Again, talk in the language of social media. They're often the worst social media policies are drafted by people who seemingly don't understand social media. Talk of in the terms that it is used. If that is something that you are not aware of, get support, get help by someone who is. make it a collaborative effort within the team. Some of the best social media policies I see are ones that have been, you know, collaboratively produced by the team, and whether that is having checklists, whether that's having standards, or the organisations stand by. They're often the best. Talked about training, provide training. A lot of social media people go, well, it's obvious I shouldn't post this, but again, it happens time and time again. Make sure that training is repeated. Who can see your profile? Again, we're talking about privacy settings and educating our staff. So now again, we're coming back to that blurred line between personal and public profiles. Yes, we want our staff to use social media to promote the organisation, but then we need to be aware of that. So, you know, talking to staff about their privacy settings. Do they identify themselves as being employed by the company? And if they are doing that, being really careful in what they post. Again, do you encourage staff to have multiple profiles, some that they can have their own private ones, but then have a company one? Often common sense. Again, update other policies link. We've addressed this already, so make sure your social media policy links to others that we've just gone about talked about. You know, bullying, anti-harassment in particular. There is a link to that. That is me in terms of the presentation finished for today. I hope you found that useful. Really good one to start off the 2022 seminar program. As I said, I think I know a number of you are already signed up for our next event. So next event, we're going to kind of focus on other areas of discrimination. Another webinar we will do next month. Event after that is going to be in April. Is our first tentative attempt at an in-person event. We're going to do that as on a part of an employment law update. So often we do an April update where we go through all the relevant legislative changes, all the case law updates, things that we are seeing in practice. For anyone who's kind of uncertain about obviously attending offices, we will record that. The office will still be limited by numbers. We're not going to shove everyone into a small room. Everyone is going to be spaced out. But it will be nice to obviously see anyone who's going to come in person. I've not seen for a number of years, but we can, you know, to bring back more of those interactive sessions would be fantastic. As always, just any questions? I don't think we've had any. No, we haven't, which is fine. Anything that you have missed from today, any more questions that you have, I won't take them today because we're bang on time, but everyone has my email, so drop me an email. Happy to share slides if you, as I say, want to repurpose them yourselves for any training. Absolutely fine. Repeat finally to leave you with that offer. I'm doing it for a number of clients at the moment. Equality and diversity is a big push for a lot of organisations at the moment. So if you would like us to come and deliver training in person, we can do that quite a cost-effective manner. We can do that as we are doing now on a Teams and use breakout rooms and train individual groups. Or again, I am happy now to come out in person and deliver those sessions to you. Can be times to fit you, half days, full days, different groups, whatever you need. So if that's of interest to anyone, please let me know, and I'll happily have a chat about what we can offer. 1 minute past 12. That's it for me today. Thank you again for attending. Anything that anyone needs, drop me a line, and I'll look forward to seeing you soon. Thank you.